Welcome everyone. Welcome to the show, The Global Resolve, Mission Mediation. This is a talk show where we invite influencers and thought leaders from across the world who share with us their perspective and their thoughts on the subject of mediation. And today we have Mr. Seppo Parviainen. He's a corporate lawyer and is based out of Helsinki, Finland. Welcome, Seppo, to the show.
Thanks, Saneb. It's a pleasure to be here.
Great. So with your permission, I'll get started right away. Why don't we have your initial thoughts on the concept of mediation and the level of awareness and the relevance of this concept in that part of the world?
Yeah, we have it, but mainly the arbitration is ruling the biggest cases, and this mediation is more like done inside the companies in commercial mediation.
So commercial mediation is a concept which is already well accepted in Finland?
Yeah, but many times the parties are having this kind of mediation between two companies, and there is not always a mediator involved in the process. It can be, for instance, commercial parties are inviting some of the inside the system helping them, but that can also be lawyers from both companies and not just outside the companies.
Okay. And have you seen evolution of mediation from what it used to be about, say 10 years back? Because lately we hear a lot of noise and voices being raised, a lot of interactions, a lot of sessions, programs ever since we had the convention, the Singapore Convention on mediation. So people have been talking more about the concept. Have you seen this concept evolving over the last decade?
It is growing, and I think the biggest reason is that this arbitration process is having so much cost inside the process that only the biggest disputes will be handled in arbitration process, and in other process mediation has been seen more flexible and good growing concept.
Got that. And so what I hear from you is that larger the stakes, right, for a case, for a dispute, that makes it, eligible for arbitration. But wherever we seek more flexibility or the stakes are lower, is that the case that the mediation only in those cases is preferred?
As I see the case that when the dispute is in value of over 100 million euros, it's normally always the arbitration, and there are very advanced lawyers and the cost level is high. But when the value is lower, they see that arbitration is having too much cost, and this mediation is better alternative. And also, as I have been working also long ago, not just in-house lawyer, but also commercial CEO, there has been a lot of so-called unofficial mediation processes between the parties. And sometimes there has been asked some mediator outside the companies. Sometimes they have involved in-house lawyers inside the mediation process.
Now, let me pick up on your, the past career where you were a commercial, in a commercial setup, you were a CEO. Now, as a commercial officer in a corporate, would you really feel that there's a difference between a solution and justice, and half of the time the disputes, what we have, whether they are in business or in employment, parties yearn for a solution, which at times may or may not be possible by a third party, going through a litigation process and looking at judge who will probably decide based on the record on the data available on record. So would you see that mediation probably can help you providing a solution versus a typical litigation?
If I think about my past history also in commercial side, there are many important reasons to find out the solution based on mediation. There is the commercial relationships between parties, meaning is that they will have good relationships many years. Also, there are many times some kind of legal analysis made before this mediation process based on that what will be the end result if there is no agreement. For instance, what would happen in the litigation process or court process. And many times this mediation is best solution when you try to find out a solution that both parties can live with, but also that it is better for the future and relationships than go to litigation process. Also, you never know what will be the end result in the court process. So anytime mediation is a good alternative. And as I see, the arbitration is more like that. Perhaps you don't want to keep any more relationships. It's more like that you want to find out the solution between parties, but not want to have the publicity.
Right. So the confidentiality part also, goes in favor of mediation, because then parties get to sit together, and then they look at the future, and they can also look at creative solutions through a give and take mechanism.
Yeah, and I have a background that based on this kind of mediation and discussion process between parties, mainly 100% we have been finding out the solution that both parties can live with, because the commercial relationship will grow and be many years after this solution. So there is reasons, try to find out the reasonable solution.
Perfect. So the relationship, the preserving of the relationship for future, continuing of the business relationship, I think is the key. I mean, that's what I hear from you, right?
Yeah, and if I look my background, it's more like commercial companies. The business cooperation and value of the business cooperation is number one anyway. And the question that there are some issues that parties don't agree, it's better to find out the common solution and then go with the business as usual, and not just trying to find out that who is winning or who is losing.
Got that. Okay, so let me just change a bit towards the legality of this entire concept. Is a doubt in the mind of the parties in dispute that a settlement which is achieved or arrived through a dialogue between the parties, it should have the force of law. So is mediation codified in Finland? Does it have any force of law in terms of accepting it as a decree of the court or an agreement which has a legal sanctity?
Normally, if you made the written and signed agreement between parties after the mediation process, it's binding both parties. That will create a new binding agreement between parties, and based on that written agreement, if there will be after that argues, you can go to court or arbitration process, but then you are in a stronger position because you have made signed agreement based on this mediation process. So that way that will give the protection.
Okay, so in case one of the parties does not adhere to the arrangement of the agreement as a sign post mediation, what you are stating is that there is an option to go to arbitration or to the court to enforce that settlement. Is it right?
I think mediation is best if you want just to find out the best solution for both parties and then have the business as usual after that. Because if you go to arbitration process, based on my experience, it will anyway hurt more the relationship between parties. And if you go to litigation process, normally the business is stopping and there will be no business after that. So that way mediation is used, but it is not always used that you take some mediator outside both parties. Sometimes there are in-house lawyers, or sometimes is asked some trustful lawyer outside the parties, and that is mediator. But many times he is not called the mediator, but that is doing the mediator's work.
Right. So what I hear is that the mediators are not necessarily chosen by the parties. There are situations where the court also can appoint a mediator, a lawyer as a mediator, maybe. Does it happen that way?
Yeah, that will happen also.
So that would be termed as a court-annexed mediation, is it right? Versus a private mediation?
If we talk about court mediation in Finland, mostly in cases when we talk about family law or children law issues, because there is a protective nature in these family law and children law issues, and there is many times that you have also some public judge involved the mediation process, and that's the different way. There is the protective need that you don't have in commercial relationships.
Okay. Let me also ask you, as an in-house lawyer, how easy or difficult it is to convince the top management at times to choose mediation as a first option, irrespective how position of dominance you already have or how strongly you feel about you being right, but it still requires some courage, some effort to explore mediation rather than sending a legal notice and say we'll see you in court. How difficult or easy it is for you to convince in such scenario?
There are a few points. First of all, always inside the companies, we make a legal analysis and look what will happen if there is no agreement, if we go to court process or if we go to arbitration. Also, it was question about parties' negotiation power. It based on how big or small the company is, what is the resources, what kind of commercial power, and all this has impacted parties' demands and also answers during this process. And so normally, if we went to the mediation process, we find out the solution that is best to have relationships, but it was not always the middle part solution. Many times that one who had bigger commercial power and resources was winning, but it was a solution that also the weaker party could agree that that was the best possible solution in this situation.
Okay. So you're saying there is definitely an assessment of every case, right? We have to do case by case and evaluate whether relationships or a middle path is possible, or relationships are the key, or depending on a scenario where you strongly feel about you being right, then one probably chooses the court option. Is that true?
That's true, but there is also one important thing. It's always issue about peoples, and if there is both parties, you should have between both parties this kind of solution-oriented approach, and also some kind of trust and will to negotiate and try to find out the solution. And as I have seen during the history, not only mediator, but also parties should have patience, experience, maturity during this process, because if, for instance, other party has a aggressive litigator lawyer representing them, this litigator lawyer is not willing to have this kind of mediation result and more like looking to go to litigation process.
Agreed. No, perfect. I think this answers of yours, gives an option to me to ask three different questions now. One is, what will be the mediator's role? I mean, is it very important, and how critical would be mediator's role to ensure that parties, if they are agreeable, then at least the process is run in such a way that both the parties are comfortable and they really opt for mediation and they are willing to go through the process. Because that's half the battle won, right?
Based on my history, there was two steps. First one was this legal analysis. What's our legal position if agreement is not made? And that has the impact of what was the targets for this mediation process. Other one was this analysis of persons involved in the process, both parties. Is there willingness to try to find out the common solution that both parties can leave or not? Many times it can be CEO's personality and also the lawyers representing both parties. And if both are positive, I mean there is a green light, both looking to legal analyze and looking to analyze of the persons involved, then there is room for mediation. But if some, for instance, persons are in red light, they are not willing to negotiate, then it doesn't help even the legal analyze show that mediation is a good option.
Okay, I understand that. And then the connected question was like, as you said, if the other party has strong litigator or litigation mindset, or they come with their legal counsels who feel strongly about the issue, do you think the entire concept of mediation is slightly compromised, or that's part of the SOPs or standard protocols, or it's part of the culture that normally parties in mediation, they come with the legal counsels?
Many times the situation is not so clear, and as I said, based on the legal analysis, based on the commercial relationship analysis, based on the persons analysis involved in the process, that will give you the answer that this mediation is possible or not. Many times it's clear that mediation would give the best possible end result for both parties. But as I said, if there is a so-called wrong persons who are not interested to go to mediation process, or if it's a situation that there will be no commercial cooperation in the future, or other party thinks that they have much more resources and commercial power, this can have an impact that there is not going to be a mediation process, even that would be the best in that situation. So we are living in the world where is a mix of all of these issues.
I would agree. I would agree. Okay, so let me change my question a bit. Can a lawyer be a good mediator? With the mindset what he has, and when I say lawyer, it's not a degree in law. Essentially, what I mean is a guy who's a litigating lawyer. He goes to the court and he has to prove, who's right, who's wrong. He has to get into arguments, he has to prove the other party wrong so that his client wins. Can that lawyer be a good mediator? Can you have, can you don two hats together? Does it work? Is it okay? Is it happening?
I think it's more a question of skills, experience, and personality. A lawyer can be a good mediator if there is right skills, experience, personality, and right mindset. There is no reason why a lawyer could not be a good mediator. But same time, a non-lawyer can also be a good mediator, and many CEOs has been good negotiators, and they would be good mediators also. But as I said earlier, that some of the lawyers are more like litigating lawyers based on the personality, or then they are doing 90% of the work as a litigator. And in that situation, some of the persons cannot change the role. They cannot be that kind of passive and neutral role that they should be in mediator, and they are much more willing to act a very strong role as a litigator. So that's the situation. So I don't think that if you are a lawyer or if you are a non-lawyer that you could not be a good mediator.
Okay. So essentially you're saying it's more about adaptability and less about eligibility, right? I mean,
Yeah, I think the personal skills and also what you are as a person, and many times this kind of combination of maturity, patience, experience is needed, and many times you need to have been in the business many years and see and handled many bad and complicated issues before you have that kind of right attitude and combination. And also this is a solution-oriented approach. This means that you really try to find out the best solution for both parties and manage the process professional way, because some of the persons has own agenda that they see that this would be the end result, and they are working to have this end result they have decided earlier, and that's not good for the mediation process.
So let me ask you, what as per you would be the right skill set for the expected of
if I would need a mediator outside company, I think the first one is this solution-oriented approach, because I would like to have a professional managed process. That is important. Then I would like to have a mediator who has maturity, patience, experience combination, but that would also help a lot if also these parties that are involved in the process would also have this maturity, patience, and experience. And as I see it, the mediator must be a trustful person for both parties. This means that both parties can trust. And this is many times coming if you have these needed skills and you are managing professional way this process, and also as a person have this maturity, patience, experience, and also it is just that you can trust this guy and this process is managed a professional way.
Right. Okay. Now, connected to the skill set, there is a follow-up question. Would you think the mediator should be a subject matter expert, or he should be more concerned about the process?
As overall, I would say that it's more like that you handle the process and can manage it professional way, and you are a trustful person and have other skills. You don't need to know all these material issues. Of course, it's great if mediator is also knowing it, and inside the in-house lawyers many times is the situation that in-house lawyers know also the business, but it's more important that you are managing professional way this process and have a trustworthy person.
Right. So for an in-house lawyer, yes, he'll be aware of the substance and the content and probably the issue more deeply. But then possibly because of conflict of interest, right? Choosing him as a mediator, as an option probably can be a tricky situation. So if we go to a third-party mediator who's, where you can have ultimate trust, absolute trust, and the neutrality, integrity is not questioned at all. So I think to that extent, he has to drive the process to the best of his ability. And to an extent, I think when things become technical, then we keep exploring an option of having an expert in between, assuming the parties to an extent know, their own side of things. So, so from that perspective, getting an expert in case of a requirement, again, is it a a normal situation or a norm in mediation in that side?
I think in Finland the biggest challenge is that if you are looking there is normally two first choices where you try to find out. Other one is the professional lawyers that are mainly doing arbitration process. And other source is some trustful lawyer that has been used or is well known, and it is taken as a mediator. And the Finnish problem is that our market size is so small that there is only 1 or 2 persons that are so-called professional mediators doing only mediation. In bigger markets, for instance, like India, perhaps it's much easier to concentrate just mediation, but in Finland, you need to have a arbitration process, and some of them are also litigators and making mediation and conciliation. So that's the challenge in Finland.
I get that. I appreciate that.
I'm sorry to interrupt, Mr. Sanjeev. I think the time is already ticking.
Yes, sure. Thank you. Thank you, guys. Right. So I think that was wonderful. And Seppo, let me thank you, for taking out time and, answering the queries and, concerns we had with regards to the mediation and speaking from heart and giving us a perspective from that part of the world. So it's always good to know that, how mediation is being tackled, how it is growing, how it is evolving in various parts of the globe. And to that extent, that's our small initiative to sensitize and make people more aware about this concept. So I thank you once again, for taking out time, and we'll definitely come back to you for some roundtables which are already planned on the same topic.
Thanks. It was a pleasure to be here, and I hope I could add something to these interesting discussions.
Lovely. Great. Thank you, Seppo. Please take care.
Thank you.
you.
Bye-bye.
Bye.